Hello and welcome to another episode of Talking Politics here at The Hindu with me, Nistula Hebbar, where we unpack the news making the headlines in domestic politics. Now, this week, the Election Commission, which had been petitioned both by the Eknath Shinde faction of the Shiv Sena and the Uddhav Thackeray faction of the Shiv Sena, for the use of the name and the symbol, for claiming the name and the symbol of that party, decided that it was going to freeze both and not basically give a verdict on who this name and symbol of the symbol of the party being bow and arrow, and the name Shiv Sena belongs to either of these factions, at least not before the Andheri East by-polls are to be held. So, what was left for these two factions of the Sena was to basically choose a name and a symbol for themselves in order to fight polls in the Andheri East by-poll, which is due on November 3rd. The Shiv Sena, Uddhav Balasaheb Thackeray, yes, that is the Uddhav Thackeray faction of the Shiv Sena, chose that name and were allotted the symbol of a flaming torch. Eknath Shinde's faction chose the name Bala Sahib Shiv Sena, which means Bala Sahib Thackeray, late Bala Sahib Thackeray's Shiv Sena, and they got the symbol of cross swords and a shield. But all of this is, of course, very exciting for everybody. We can get back to revising how parties get symbols, what do names mean, how historically all of this has happened, how did the Shiv Sena get the name, etc., etc. But that is not going to be the subject of this episode of Talking Politics. We are going to actually look at the split verdict delivered by the Supreme Court in the hijab case, a case where the Karnataka High Court's ruling on banning the use of hijab inside government institutions, etc., educational institutions, was appealed, and that appeal was being heard, but none of the people who were looking for clarity on this issue, either the government or the appellants, got any clarity. It was a completely split verdict between the two judges. And now that particular case will again be heard, but before a three-judge bench headed by the Chief Justice of India. We are basically just going to go through what exactly happened, what was the split verdict, and what has been the impact of this split verdict. So, for the sake of clarity, entering into this topic, let us just first look at the timeline of what has happened in the hijab case so far. What was the provocation? Why did people feel the need to go to court? What was the government's position? And what exactly happened on October 13th? Well, it all starts on January 1st, 2022, when six students of a pre-university college in Karnataka's Udupi district were not allowed to enter their classes wearing a hijab. The students held a press conference where they said that permission was sought, but that college authorities refused to let them enter the classroom with their faces covered. The students barred from the classroom started protesting against the college administration. Now, Mr. Rudragowda was the principal of that Udupi college, said that the students used to wear the hijab to the campus and enter the classroom after removing the scarf. So basically, he said they used to enter the gate of the university or the campus of the university, and just basically before entering classes they used to remove the hijab. And he said basically now we didn't the college doesn't have any rules with regard to hijab, because that was never a problem for the last 35 years, because that was how they did things. You enter the campus, and while entering the classroom you remove the hijab. And basically, he also said that the demand from students who said that they wanted to wear the hijab, that demand was being stoked by outside forces. What he didn't say, and what was later picked up by the BJP, was that the accusation was basically being made against the now banned PFI and the SDPI, which was the student wing, and that SDPI was encouraging Muslim students to insist on wearing the hijab inside classrooms, which was not been done in the past, and it was a new thing, etc., etc. And basically, a lot of protests broke out, and there was competitive politics on the issue in Karnataka. So much so that the Karnataka government on January 26th decided to set up an expert committee to go into it. They felt that some rules needed to be in place in terms of what was happening, because if it happened, if it persisted, if this kind of a confrontation went on for long, it would lead to a lot of conflict, and may also kind of lead to a loss in educational days for other students as well. So then on January 31st, these students who want to wear the hijab inside the classroom, they went to the Supreme Court against the curbs that their college administrations had put up. They basically wanted a declaration that wearing the hijab was a fundamental right guaranteed under the Constitution of India. On February 5th, the Karnataka government, through its expert committee, said that nothing doing. We are imposing a ban on hijab in classrooms. People can wear it outside in their private lives, in other public spaces, but inside classrooms, in educational institutions, a strict adherence to the uniform requirements has to be done, and therefore hijab was not allowed, and it was banned inside classrooms in the state. Immediately after that, on February 8th, clashes broke out, not just in Udupi, where this issue first started, in coastal Karnataka, where a lot of communal polarization already exists, but also in places like Shivamogga, where Section 144 was imposed against public gatherings because things turned violent. So much so that Karnataka Chief Minister Basavaraj Bommai ordered the closure of educational institutions for a few days. On February 10th, the Karnataka High Court passed an interim order saying that till they decide on something, students can't be allowed to wear any piece of clothing that is religious, that gives basically a signal of religious differences. And in short, basically they said that don't wear the hijab till we decide on whether or not you can wear it. On February 11th, petitions were filed in the Supreme Court against the High Court's interim orders. On March 15th, the Karnataka High Court finally came out with the ruling, and it said that hijab was not part of essential Islamic religious practice. It said this is not part of your essential practice of religion, therefore the fundamental right issue cannot be applied. And they basically upheld what the Karnataka government had said, that there was a ban on wearing a headscarf or hijab inside educational institutions. This verdict of the Karnataka High Court was immediately challenged by appellants hours after the judgment before the Supreme Court. Finally, on July 13th, the Supreme Court agreed to hear petitions filed by against the Karnataka High Court's verdict. On September 26th, when arguments were concluded, the Supreme Court said we reserve the verdict on pleas. And 3 weeks later, on October 13th, basically they said they delivered a split verdict. This was a two-judge bench which delivered a split verdict. That is, the judges could not agree with each other on what should be done. There was no unanimity. One judge said one thing, argued one point. The other judge came out with another verdict. Now, let's go into exactly what that Supreme Court split verdict was. Well, the Supreme Court on Thursday delivered a split verdict on whether Muslim students should shed their hijabs at their school gates. Justice Hemant Gupta upheld the Karnataka government's prohibitive order on February 5th, saying apparent symbols of religious belief cannot be worn to secular schools maintained by state funds. He said secularity meant uniformity, manifested by parity among students in terms of uniform. Basically, he said that if the state is funding schools, the state is a secular unit. If it's giving money to run schools, then all students must be considered the same. They should all wear the same uniform. There should be no manifestation of religious difference. Uniformity meant parity. Uniformity meant equality for everybody. So, uniformity for him meant equality in terms of the state paying for your education. Justice Gupta held that the adherence to the uniform was a reasonable restriction to free expression, also right to free expression. He said that you have the right to free expression, but that ends because of the restrictions of uniforms, because the state is paying for education, it is subsidizing your education, and therefore if the state, that particular educational institution, has to treat everybody the same and has therefore brought in a uniform which looks the same, it is your duty to wear that and not a headscarf. The discipline of the uniform reinforced equality according to him. He It said the state had never forced students out of state schools by restricting the hijab. The decision to stay out was a voluntary act of the student. In his divergent opinion, and now we come to Justice Sudhanshu Dhulia, the other judge in the case, who gave a diametrically opposite view of this issue. He said that secularity meant tolerance to diversity, where Justice Gupta said that uniform wearing of the uniform meant equality and parity. He said secularism meant tolerance to diversity. So if the state is funding you, your education, these are state-funded institutions, the secularism and state is a secular unit, then that secularism also means tolerance to diversity. It doesn't just mean uniformity. You're just treating everybody the same and forcing everybody to wear a particular uniform. You can treat everybody the same in terms of the education that you give, but what they choose to wear should be their choice. He said wearing or not wearing a hijab to school was ultimately a matter of choice. For girls from conservative families, he said, and I quote, her hijab is her ticket to education. Basically, he said that in conservative families where family members felt awkward about sending their children, the girl child, out to study because of various reservations, girl child could say that, look, I'm wearing the hijab, I'm modestly dressed, I'm following the tenets of the religion, of the conservative requirements, and can I please have an education? I'll go to school, and I want an education, and I'm prepared to follow these rules. So he's basically said it was a ticket to education. It allowed conservative families also to send their children out. He said by asking the girls to take off their hijab before they enter the school gates is first an invasion of their privacy, then it is an attack on their dignity, and ultimately it is a denial to them of secular education. There is no restriction, there shall be no restriction in wearing the hijab anywhere in schools and colleges in Karnataka, Justice Dhulia said. He said one of the best sights in India was a girl going to school like her brother. He said, are we making the life of a girl child any better by denying her education merely because she wears a hijab? All the petitioners wanted was to wear a hijab. Is it too much to ask in a democracy? How is it against public order, morality, or health, or even decency, he asked. Now, the result of the split verdict is that the matter will now have to come before a three-judge or a larger bench, likely headed by Chief Justice of India, UU Ladit, at the moment. And while political reactions to the split verdict were on expected lines, with the All India Majlis-e-Ittihadul Muslimin, headed by Asaduddin Owaisi, and the BJP agreeing with one judge and disagreeing with the other, you can know pretty much which judge either of these two parties would be agreeing with, the Congress decided to sit this one out simply by reiterating that the matter will continue to attract the attention of the Supreme Court. Basically, they wanted to see what the Supreme Court was going to say on the hijab matter. Now, this issue of wearing or not wearing the hijab is a very complicated, layered sort of issue. And across the world, it is also contextualized by the political situation in those countries. Political Islam, reiteration of Islamic values, or Islamic values being interpreted, or the Quran being interpreted in certain ways. So it's all caught up with all of those things. It's been framed in different ways by different people. The Orthodox among the Muslims have framed it in religious terms. They say it is enjoined, the Quran enjoins that women wear a hijab as a sign of modesty. Others have framed it as a matter of choice in interpreting faith, that women with a certain degree of agency are expressing their faith in a certain manner of dress, and that choice should not make it impossible for them to get an education. The government of Karnataka has framed it as a question of uniformity and institutional rules and regulations and the rights of the state to prevail over heterogeneity when they are basically subsidizing your education. In such a scenario, the split verdict of the Supreme Court is therefore not hard to understand. It is a very difficult sort of situation to get around, but it underlines the fact that the larger bench will have to, in its resolution over the issue, not just be conscious that it will be pronouncing their judgment on the hijab, but the way they pronounce it, the framing that they choose will also decide a lot of things going into the future in terms of gender rights and uh, freedom of religious practice. This is all I have for you this week. Thank you very much for watching.